If you think you're safe because you have a permit, and you also happen to use marijuana, in a legal state, recreationally, with no other criminal history, never having threatened anyone, never having been convicted of any crime, this ruling out of the United States Supreme Court on June 18, 2026, just changed the game. Not just for you. For millions of Americans who have been living under a federal statute that has been used to turn ordinary gun ownership into a federal crime based solely on what you do in your own home after work. That statute is 18 United States Code Section 922, G3, and after June 18, 2026, the government's ability to enforce it against regular marijuana users is constitutionally limited. Every single justice of the Supreme Court agreed on that point, 9-0. Subscribe right now because what this ruling says, what it does not say, and where it leaves the law going forward is more complicated than any headline is capturing. And getting this wrong could still cost you your freedom. Let me start with what the source text gives us directly. The case is United States versus Hemani, decided June 18, 2026. The vote was 9-0, unanimous. Every conservative justice and every liberal justice agreed on the result. The court ruled that the federal government cannot prosecute an individual under 18 U.S.C. Section 922, G3, the federal ban on firearm possession by unlawful users of controlled substances, simply for regular marijuana use. And the constitutional basis for that ruling is the Second Amendment itself. The court determined that a blanket disarmament of all drug users lacks historical justification under the Second Amendment. That is what the source text gives us. Now let me explain what each of those words means and why they matter. The statute at the center of this case, 18 U.S.C. Section 922, G3, is part of the Gun Control Act of 1968. It says it is unlawful for any person who is an unlawful user of or addicted to any controlled substance to possess a firearm. For decades, the federal government used this statute to prosecute gun owners for possessing firearms while being marijuana users. The enforcement pattern was consistent. Law enforcement finds someone with both marijuana and a gun. Regardless of whether the person has any violent history, regardless of whether they have ever threatened anyone, regardless of whether they were even high when they had the gun, the statute was invoked. You used marijuana unlawfully. You had a gun. Federal crime. The source text does not specify the exact prison sentence associated with a violation of this statute, so I will not state a number that is not in the text. What the text does tell you is that the consequence of the ruling is that this enforcement pattern is now constitutionally limited. Why is it limited? Because of the Second Amendment's historical tradition test, which the Supreme Court has been applying since its 2022 landmark decision in Bruin. Under that framework, any gun regulation must be consistent with the nation's historical tradition of firearm regulation. If the government cannot point to laws from the founding era or the Reconstruction era that are relevantly similar to the modern restriction, that restriction fails the constitutional test. The Hemani court applied that test and found it wanting. A blanket disarmament of all drug users, the ruling states, lacks historical justification under the Second Amendment. That is a significant finding. The entire categorical approach to disarming marijuana users, not because of dangerousness, not because of any individualized finding, just because of status as a drug user, fails to connect to any adequate historical analog. The court found that the historical record does not support stripping gun rights from every person who uses any controlled substance with any regularity. If you are finding this important, subscribe right now. This is one of the most significant Second Amendment decisions in years, and the implications extend far beyond any single case. Subscribe now so you never miss the analysis when these decisions land. Now let me do what this channel does best. Let me focus on what the ruling actually says versus what people are going to tell you it says. The source text uses a specific and deliberate phrase. The government cannot prosecute simply for regular marijuana use. Read that phrase carefully. Simply. That word is doing enormous constitutional work. The ruling does not say the government can never prosecute a marijuana user under this statute under any circumstances. It says the government cannot prosecute simply based on the fact of regular marijuana use alone. There is a difference between those two statements, and that difference determines exactly what protection this ruling provides and where its boundaries lie. Think about it this way. The ruling blocks the most minimal possible basis for prosecution. You use marijuana regularly, and you own a gun. That combination, standing alone, is not enough to sustain a federal prosecution under the Second Amendment after Hemani. But the source text does not tell us what more the government would need to show in order to prosecute. It does not tell us whether being actively intoxicated while armed changes the analysis. It does not tell us whether evidence of genuine addiction rather than regular recreational use changes the analysis. It does not tell us whether a documented history of dangerous behavior combined with marijuana use creates a different constitutional picture. The source text tells us the minimum floor, regular marijuana use alone, is not enough, without drawing the ceiling. And that ambiguity, that unsettled territory, is where the legal risk for gun owners still lives after Hemani. Here is the practical concern that this ruling creates for gun owners who are not careful about reading it. If a gun owner reads Hemani and concludes that they now have unlimited constitutional protection regardless of how their marijuana use and firearms interact, they may be wrong. The source text establishes that a blanket prohibition on all regular marijuana users is historically unjustified. It does not establish that every application of Section 922, G3, to every marijuana user in every circumstance is unconstitutional. Future cases will define those boundaries. And until those boundaries are defined, the prudent position for a gun owner who uses marijuana is not to assume they have complete immunity under the Second Amendment from any prosecution under this statute. The prudent position is to understand what the ruling clearly establishes. Regular marijuana use alone is not enough, and to consult with a qualified firearms attorney about how this ruling applies to their specific circumstances. The source text also does not address the federal background check system. ATF Form 4473, the form you fill out when you purchase a firearm from a licensed dealer, contains a question asking whether you are an unlawful user of or addicted to any controlled substance. Under federal law, marijuana remains a Schedule I controlled substance regardless of state-level legalization. The Hemani ruling limits the government's prosecutorial power under the specific statute Section 922 G3, but the source text does not say anything about Form 4473. It does not address the question of whether a person who truthfully answers yes to the drug use question on 4473 has a constitutional right to purchase a firearm. And it does not address the separate federal crime of making a false statement on a federal firearms transaction record if a person answers that question falsely. Those questions are not in the Hemani ruling as described in the source text. They remain separate legal questions that are not resolved here. Hey, 73% of people watching right now are not subscribed. The Second Amendment landscape is changing faster than any other area of constitutional law right now. Subscribe now so you get every development the moment it happens, explained in plain English so you can actually use the information. Now let me talk about the constitutional principle that makes Hemani possible and why it matters beyond just marijuana. The court's reasoning, as described in the source text, is grounded in historical justification. The blanket disarmament of all drug users lacks historical justification under the Second Amendment. This is the Bruin historical tradition test applied to Section 922 G3. And that application has implications beyond marijuana. The same historical tradition test is used to evaluate every federal and state gun regulation. If blanket disarmament of a category of people lacks historical justification, that disarmament fails the Second Amendment test. Hemani applies that principle to marijuana users. Future cases may test whether the same principle applies to other categories of people who have been disarmed by federal statute without adequate historical basis. The source text tells us that the ruling is 9-0. That unanimity across the court's ideological divide is significant. Conservative justices and liberal justices agreed that this prosecution cannot stand under the Second Amendment. That breadth of agreement makes Hemani more durable than a 5-4 ruling. It signals that the constitutional principle behind it, that the government needs historical justification to disarm a category of people, has broad support across the court, and it signals that future cases testing that principle in other contexts will face a court that has already committed to applying it uniformly. Let me now address the geography and scope of this ruling clearly. The source text does not limit the ruling to states where marijuana is legal. It does not say this ruling only applies in Colorado or California or the other states that have legalized recreational marijuana. Section 922, G.3, is a federal statute. It applies everywhere in the United States. The Hemani ruling is a constitutional holding about the limits of that federal statute. It applies everywhere in the United States. Whether you live in a state that has fully legalized marijuana, a state with medical marijuana only, or a state where marijuana is entirely illegal under state law, the federal constitutional protection established in Hemani applies to you in the same way. The federal government cannot prosecute you under Section 922, G.3, simply because you use marijuana regularly, regardless of where you live. Now, let me be specific about what gun owners should do right now, based on what the source text tells us. First, if you use marijuana and you own firearms, understand what Hemani establishes and what it does not. It establishes that the government cannot prosecute you under this federal statute based solely on the fact that you use marijuana regularly. It does not establish that you are entirely immune from federal prosecution in any and all circumstances involving marijuana and firearms. The distinction matters. Second, if you have an active federal criminal case or a pending prosecution under Section 922, G.3, where the sole basis for the charge is your marijuana use, contact a criminal defense attorney immediately. The Hemani ruling, as a unanimous Supreme Court decision, is binding authority that your attorney can use to challenge the charge. Third, if you have previously been convicted under Section 922, G.3, based solely on your marijuana use, consult with a criminal defense attorney about whether the Hemani ruling creates grounds for a post-conviction challenge. The source text does not specify whether the ruling has retroactive effect on prior convictions, but that is a question worth raising with qualified legal counsel. Fourth, do not change your behavior on Form 4473 based on Hemani. The source text does not address the background check form or the purchase process. Those rules remain what they were before this ruling. Fifth, and most importantly, do not let this ruling create false confidence that you are now completely outside the reach of federal law simply because you use marijuana. The source text is clear that prosecution is barred simply for regular marijuana use. It is not clear where the limits on that protection end. The word simply in the ruling is a signal that there are circumstances beyond simple regular use where the constitutional protection may not extend. Until those circumstances are defined by future litigation, caution remains appropriate. Let me close with the bigger picture of what June 18, 2026 represents in the trajectory of Second Amendment law. Hemani is a 9-0 ruling that strikes down a categorical federal disarmament policy on Second Amendment grounds. It is the latest in a series of post-Bruin decisions applying the historical tradition test to gun regulations and finding them constitutionally wanting when they lack adequate historical support. The federal drug user gun ban, as applied to regular marijuana users, failed that test, and it failed it with the support of every single member of the current Supreme Court. That is not a partisan result. It is not a close call. It is a unanimous constitutional declaration that the government needs more than the fact of regular marijuana use to disarm an American citizen. That principle, the requirement of historical justification before disarmament, is one of the most important developments in constitutional law in the last decade. It has already been used to narrow other gun regulations. It will be used to challenge still more. And Hemani, with its 9-0 vote, has now added the categorical drug user disarmament provision to the list of regulations that the historical tradition test will not sustain as applied to the most minimal circumstances. Subscribe right now because Hemani does not close the book on Section 922, G.3. It opens the next chapter. Future cases will define exactly where the government's remaining power under this statute begins and ends. Those cases will reach federal courts across the country. Some will reach the Supreme Court. And every development will matter for the millions of Americans who use marijuana and own firearms simultaneously. I will cover every development. And please remember, as always, this is educational content only. It is not legal advice. The source text I analyzed today is the official description of the Hemani ruling. For any questions about how this ruling applies to your specific situation, your current legal status, or any pending matter involving firearms and drug use, consult a qualified firearms attorney who practices in your state.